Hi folks, and welcome back to Contract Law. This is video 4 in the series of videos on contents of a contract and exclusions. And just a quick recap, in video 1 we had a little look at where are the different places you might look to find contract terms, because they're not just going to be in a written agreement. Possibly they may be lurking in other places. And then we really kicked things off by video 2 looking at the parole evidence rule. That is the rule of the game, basically, that assists courts by determining what evidence can be brought in to establish whether or not something is going to be a contract term. Then in video 3 we had a little look at the terms themselves and how you work out whether the parties intended a term to be a justiciable term, a contractual term, or not. Obviously that helps the courts when they are looking around trying to work out if the parole evidence rule should apply. We also had a little look at classification of terms. And now we are left with the two principal areas in the next couple of videos where you might find terms lurking apart from the main written contract. And in this video we're going to be looking at collateral contracts. Okay, so here we are. Now, collateral contracts, in the first video I kind of said to you, that the main contract might be ticking along quite nicely, and then all of a sudden you'll find that one of the parties says, hang on a minute, there's this other collateral contract that kind of floats alongside of the main contract and qualifies it in some way. It is just another way for a party to try and have a term enforced. So collateral contracts are one of the labels that get applied to these terms that are outside of what looks like the party's main bargain, but nevertheless are enforceable. Collateral contracts, like I just said, the other main way of getting terms in is by incorporation. We'll look at that in the next video. The one other thing that I wanted to mention in terms before we get into collateral contracts is the main other alternative to arguing that a term should be enforced as a collateral contract is arguing that a term should be enforced by way of estoppel. And we'll look at estoppel in a different video. But you should just be aware for completeness that that is another principal way of having a court enforce a term that falls outside of that main agreement, but nevertheless was intended by the parties to be justiciable. So collateral contracts are the label that we are looking at this video. How do you get the evidence in to establish a collateral contract in the first place? As we saw in video number 2, collateral contracts are one big exclusion to the parole evidence rule. So you can certainly introduce evidence to try and convince a court that whatever has been said or done should be enforced as a collateral contract. So in a way it kind of collateral contracts cause some collateral damage to the parole evidence rule. Okay, so the two main requirements for introducing collateral contracts, and these are just common sense really, nothing terribly tricky here. Firstly, the representor must have intended the promise to be legally binding. Now, if you think back to what we were just saying about the parole evidence rule, just makes sense, doesn't it? Because the parole evidence rule is going to exclude anything else apart from the written terms if the parties intended those written terms to constitute the whole of the agreement between them. So the trick to actually avoiding the parole evidence rule is to show that the parties actually intended this other stuff that's floating out there around the edges of the written contract to be contractually binding as well. So obviously there's your first requirement there. Excuse my dog. Secondly, the representee must have relied on the promise in entering the main contract. Excuse my dog. And that will become apparent. The reason for that requirement will become apparent in just a moment. So the case that we look at, generally speaking, here is De La Salle and Guildford. Classic kind of, pre-tenancy discussions that went on there. Negotiations for lease of a house. Tenant said, okay, I'll sign the lease. Hang on a minute, you're not going to get my copy of the lease and therefore have a completed, executed contract, signed contract, unless you tell me that the drains in this place are of good working order. And of course the landlord says, yes, sure, they're fine. Obviously they weren't, and so therefore we had the dispute here. The landlord said, well, you can't sue me for damages here because there was never any contractual term warranting that the drains would be in good order. The court said no, actually. Guess what? That assurance, that verbal assurance that occurred before you signed on the dotted line there, that assurance formed a collateral contract, a separately enforceable contract that floats alongside the main contract. And the only reason why the tenant actually went ahead and bound themselves to the main contract was because of that verbal assurance. Like I said, not rocket science, but there we go. The label collateral contract gets applied to that term that gets enforced. However, don't, from what I've just said, think that getting a collateral contract recognised by a court is an easy thing. It's certainly no lay down misere. The fact is that collateral contracts are an exception to the parole evidence rule, and the parole evidence rule, as we saw from video 2, is fairly carefully guarded by the High Court at the moment, at least. And so, generally speaking, if there is a written agreement between the parties, then terms will be expected to be in the body of that main agreement. If the parties wanted it, it would be there. However, courts might be a little more receptive to arguments of a collateral contract if it relates to something a little out of the ordinary, something that might not have formed part of the main body of terms in the written agreement. And here's where we get the Shepherd and Municipality of Ryde case. Again, nothing fancy, just shows this particular point. There was a sale of land in a housing estate to Shepherd. The council gave Shepherd a brochure showing that the land opposite where they were going to purchase was going to be reserved for parks. You can guess what happened. The land was purchased by Shepherd, and then the council thought, here's a money-making opportunity. We're just going to subdivide that land across the way there and make more money for ourselves. That whole idea of a park, yeah, that goes out the window. We're after the dollars instead. Of course, Shepherd wasn't very happy at that development, sought an interlocutory injunction to restrain the council from subdividing that land and selling it off. And Shepherd won, okay. Reason being, because even though there was a sale and purchase agreement there between him and the municipality, they said that this issue of whether or not the land adjacent was going to be reserved for parks or not was something a little more unusual, and it was certainly acceptable to show that the evidence read in light of the pamphlet depicting the parks opposite could operate as a collateral contract. So where a term contains something a little more unusual apart from the run-of-the-mill term that might be in the main body of the contract, then you might find a collateral contract exists. Again, you've got to show, because collateral contracts exist at common law as a fully fledged contract, you need to show all the basics of contract formation. So you've got to show agreement, you've got to show your offer and acceptance, you've got to show your consideration, you've got to show things like intention to create legal relations and capacity and all of that stuff. So in terms of agreement, normally we talk about the Savage case. In that particular case, it was a sale and purchase of a boat as spec'd up by a particular engine. There was an exchange of correspondence, and in the exchange of correspondence, the seller indicated that this particular engine would probably be able to reach this certain speed. The purchaser wrote back and said, yes, okay, I think I'll have the boat equipped with that engine because that speed might come in handy. You can guess what happened. Bought the boat with the engine, couldn't reach that particular speed, not well anyway, and the question was, you know, could the exchange of correspondence form part of the contractual terms between the parties? It wasn't in the main sale and purchase agreement. Could it operate as a collateral contract? In that particular case, the court held no, because there hadn't been a firm promise in terms of your offer and your acceptance. Remember, you've got to have a promise there, a clear promise capable of acceptance. There was no firm promise that the boat spec'd up with this particular engine was going to reach that particular speed. Okay, consideration you also have to have for collateral contracts. Usually that will be between the two parties to the main contract, and it will be said, generally speaking, that the consideration for entry into the collateral contract was entering that other party going ahead and entering into the main contract. Shepherd and the municipality of Ryde, as we just saw, where we had the sale and purchase of land and the assurance being given about the park across the road. They wouldn't have entered that sale and purchase agreement unless they'd had that assurance about the parks. It can get a little trickier, and the text goes into this, where you have a tripartite arrangement in terms of consideration. So if you think back to our videos on consideration, sometimes consideration for one party entering into a contract can be that the other party to the deal enters into a contract with a third party, and that can be the same for collateral contracts as well. So in the Shanklin Pier case, I'll just choose that as an example, you had a pier company that was running a pier, so you know those long jetties by the seaside, needed repainting, and the producer of certain paint convinced the pier company to stipulate in its contracts, its tenders that it tendered out to all of the painters, it stipulated that this particular kind of paint should be used when these painters were quoting up, you know, whether they would do the job. They chose a painter that did use the paint that was stipulated in the contract, and instead of having this nice long life, it was terribly defective and showed signs of wear and tear very, very quickly. So in that case, Shanklin Pier could sue the paint producer, Detail Products, and its consideration for this collateral contract was that the pier company had entered into the contract with the painter, stipulating that their paint, Detail's paint, should be used. So you need to find consideration. No real problem there. Similar kind of thing in the Wells case. Similarly, you also have to show intention to create legal relations, obviously, because your term has to be promissory. You have to intend it to have contractual significance. So in the hospital products and US surgical court case, where we were talking about the parole evidence rule, and that was the case that involved the distributorship arrangement between the Australian distributor and the US surgical company. That representation that they would only be distributing US surgical courts products and nobody else's products was held to be a term of the contract between the parties. It operated as a collateral contract. So, and the intent there obviously was that that representation was going to be contractually binding. So all of the nuts and bolts that you need to show for an ordinary contract have to also be evident in a collateral contract before a court will find that a collateral contract exists. And the final principle is that the collateral contract can't be inconsistent with the terms of the main contract. And that really just makes sense, doesn't it? Because if you've got a main contract ticking along quite nicely, and then you start to say, well, hang on a minute, there's this collateral contract as well that operates alongside it and qualifies it, you can't have it being inconsistent, otherwise which one would prevail? It just doesn't really make sense. That principle was established in Hoyts and Spencer, and so in that particular case you had a head lease, lessor lessee, and then the lessee of the head lease subleased to a sublessee, and in the lease between the lessee and the sublessee, it provided that the lease could be terminated at any time on 4 weeks' notice. However, in discussions between the parties prior to signing off on that term, the sub-lessee had discussed the matter with the lessor, and they said, well, no, we won't actually exercise that right to terminate unless the head lease is terminated as well. And you can guess what happened. The right to terminate was purportedly exercised, and there was an objection made to that. And you can't have a collateral contract, this verbal assurance that the termination wouldn't happen unless the head lease fell over. You can't have that being held to be a collateral contract because the written terms of the main contract were directly inconsistent. So it just really makes sense, doesn't it? The final thing to cover off is what happens if a collateral contract is breached. And in particular, probably the most pressing question between the parties will be, if there's a breach down here, what happens to the main contract? Can you argue that a breach down here should enable you to terminate the main contract? And as you'll recall from our video on terms and classification of terms, no, you can't. Just because there's a breach down here doesn't mean you can terminate up here. Okay, breach down here doesn't equal super serious ability to terminate the main contract. So you can't do that. You can only get damages for breach of your collateral contract. You can't get specific performance of the main contract either. Remembering, and this again all only makes sense because the collateral contract is a separate contract in and of itself. So just because there's a breach down here doesn't mean that you can dictate what's going to happen up here. So you can't get termination, you can't get specific performance of the main contract there. Normally damages will be the amount equal to the diminished value of the main contract. As I said at the very top of this video, if you're not successful in arguing that a term should be enforced as a collateral contract, what other options are there? Estoppel is one, and you might also argue some vitiating factors if you want to get some remedies. So if this verbal assurance or whatever it is that you want to enforce or get a remedy for can't be enforced as a collateral contract, you might find that the naughtiness of that probably verbal assurance might constitute misrepresentation or misleading or deceptive conduct, two vitiating factors that we will talk about in another video. So just because you fall over on a collateral contract argument doesn't mean it's the end of the day. There might be some other things that you can argue in the alternative, and they are your most likely range of alternatives there. So that is the issue of collateral contracts. And we'll leave this video here and we'll come back for our final video on the incorporation of terms. Bye guys.